All right, let's make this simple. Show me proof you're in this country legally.
And what authority do you have to ask me that while I'm filling up my
If you
car?
don't prove you're a citizen right now, you're going in
I'm a
cuffs.
citizen and a lieutenant with 11 years.
At a gas station on an ordinary afternoon, a black man in a plain t-shirt was leaning against a pump filling up his car. Nothing about that scene was unusual. It was the kind of stop anyone makes dozens of times a year without a second thought. Get out of the car, insert the card, wait for the tank to fill, move on. The sky was clear, the station was busy, and there were other cars and other people around. There were no sirens, no chase, no context that would justify what happened next. 2 ICE agents, Immigration and Customs Enforcement, approached him in full tactical gear, ballistic vests, rifles, faces covered by masks, and blocked the exit with the posture of people surrounding a dangerous fugitive. The body camera of one of the agents captured the exact moment when one of them looked at the man and said, with the ease of someone who believes they are in complete control of the situation, "All right, let's make this simple." What those agents didn't know in that moment, and what the body camera recorded in real time as the situation unfolded, was that the person they had cornered at a gas station with military-grade equipment was Lieutenant Kemba Davis, a black police officer with more than 15 years of service in a metropolitan police force in the American South. She was off-duty. She was in civilian clothes. She was doing exactly what any ordinary citizen would do on a weekday afternoon. And she was about to experience one of the most absurd and revealing moments any law enforcement officer has ever faced on American soil. Being treated by colleagues within the same system as though she were an undocumented immigrant based on absolutely nothing other than the color of her skin. The story of Kemba Davis is not a story about immigration. It is not a story about ICE procedures or border policy or any of the debates that usually dominate conversations when that agency's name appears in the news. It is a story about what happens when racial prejudice is so deeply embedded in a system that it operates automatically without requiring conscious intent, without requiring a declared villain, without requiring any trigger other than a person's appearance. It is a story about how 2 armed federal agents at a busy gas station looked at a career law enforcement officer and saw something entirely different from what she was. And it is a story about what happened after footage of that moment became public. Before we go any further, I want to ask you something. Subscribe to this channel right now and drop a comment telling me what city you're watching from. Because this story is not an isolated case from a specific state or a specific department. It is a pattern that repeats itself in places, in situations you may have witnessed without fully understanding what was in front of your eyes. And this particular story has a level of documentation and legal consequences that makes it one of the most important cases in recent years for understanding how institutional prejudice operates in practice, not in theory. ICE was created in 2003 as part of the reorganization of the Department of Homeland Security following September 11th. Its stated mission is to enforce federal immigration laws and protect national security. ICE agents have the authority to approach, detain, and arrest people suspected of immigration status violations. But that authority has very specific legal limits. They need reasonable basis to believe a person is undocumented before initiating any compulsory contact. What they cannot do, legally, is approach people randomly based on racial profiling, which means the central question at that gas station was not whether Kemba had documents. It was what specifically had led those 2 agents to approach her in the first place. And when that question was asked during the legal process that followed, the answer revealed something the department would have much preferred to keep out of the public record. The body cam footage from that day runs less than 4 minutes, but each of those minutes contains layers of information about how power operates, about how authority is distributed unequally, about the gulf that exists between what institutions say they are and what they demonstrate themselves to be when the camera is running, and no one has yet realized that the person being approached has the means to transform that moment into a federal lawsuit. In 4 minutes, 2 agents built the case against themselves without realizing it. And Kemba Davis, with the composure of someone who spent 15 years knowing exactly how to behave when everything around them is going wrong, let them do it. It was a Thursday in October when Kemba Davis stopped at that gas station in the metropolitan area of Savannah, Georgia. She had left earlier than usual that day because She had a medical appointment and needed to fill up before getting on the highway. She was wearing jeans, a dark blue t-shirt, and sneakers. The clothes of someone who is off duty, who has nothing to prove to anyone, who is living the kind of anonymous and inconsequential afternoon that everyone deserves to have once in a while. She inserted her card into pump number 4, selected her fuel grade, and was waiting for the tank to fill when she caught out of the corner of her eye 2 unmarked black vehicles pulling into the station at a speed and angle that were not those of someone who came to get gas. The 2 agents who stepped out of those vehicles were wearing equipment more appropriate for a high-risk operation in a conflict zone than for an approach at a commercial gas station on an ordinary afternoon. Full tactical vests, rifles at the ready, faces covered by masks, active radios. The agent leading the approach was named Derek Hollis, with 6 years at ICE, most of them in field operations across the southeastern United States. The agent accompanying him was Sarah Pruitt, with 4 years at the agency. Both were part of a special operations unit that had received that day a location order for a specific suspect, an undocumented male immigrant, approximately 35 years old, who had been seen in the area driving a dark-colored vehicle. That was the profile. Vague, imprecise, no photograph, no full name, no identifier that could distinguish the person from any other human being who loosely matched that description. Kemba was 38 years old. She was in a dark vehicle. She was in an area that coincidentally overlapped with the search zone the unit had been assigned. And she was black. That was enough. Hollis and Pruitt made no further checks before approaching. They did not run the vehicle's license plate through the database, which would have immediately revealed that the car was registered to an American citizen with no record. They did not observe the person long enough to notice that her behavior was completely inconsistent with someone trying to avoid federal attention. They did not consider the possibility that the description they had was so generic it applied to a significant portion of the population of that city. They saw what their bias was programmed to see, and they acted on it. Hollis's body camera had been running since the moment he stepped out of the vehicle. The footage shows both agents approaching pump number 4 with Kemba between them and the gas station behind her. It shows Hollis positioning his body to block her left side while Pruitt covered the right. It shows Hollis's rifle not aimed, but in a position that anyone with training would recognize as immediate readiness. The difference between that position and a direct aim was a fraction of a second of decision, and it shows Kemba's face in the moment she realizes what is happening. There is no panic in that face. There is recognition, the kind of recognition that comes from years of training and from a lifetime of understanding that certain moments demand absolute control, regardless of what you are feeling on the inside. Hollis got straight to the point. He said he was looking for someone and needed to verify her identity. He used the tone agents use when they want the other person to understand there is no room for negotiation. Not aggressive in the sense of shouting or explicitly threatening, but with that calculated firmness that is designed to communicate that compliance is the only available option. Kemba responded with a composure that, watching the video, is almost difficult to believe. She asked, directly and without hostility, what the legal basis was for that stop. She did not give her name yet. She did not present identification yet. She asked for the legal basis because she knew exactly what was happening, knew exactly what her rights were, and knew exactly that that question had the power to reveal, in the agent's own words, whether or not there was any foundation for that interaction. Hollis did not have a good answer to that question. What he had was the mission order, the vague suspect profile, and the assumption that the person in front of him was not in a position to challenge federal authority at a gas station with 2 armed agents blocking the exit. What he did not have was probable cause. What he did not have was reasonable suspicion based on specific and observable behavior. What he did not have was any concrete element connecting Kemba Davis to the suspect he was looking for, beyond general physical characteristics that described thousands of people in that city. And when he attempted to articulate a justification, what came out was exactly the kind of vague and circular response that Kemba's attorneys would later use to demonstrate that the stop had never had legal foundation from its very first second. There is a specific moment in the body cam footage that civil rights attorneys described as the turning point of the entire case. Not the moment of the initial approach, not the moment Kemba asks for the legal basis, but the moment that comes right after, when Hollis realizes his answer was not sufficient and decides to escalate. Rather than stepping back, rather than reassessing whether there was any real foundation to continue that interaction, he did what agents in positions of authority frequently do when they feel control of a situation slipping from their hands. He increased the pressure. He told Kemba that her cooperation was necessary for everyone's safety, that the situation could be resolved quickly if she simply provided her documents, and that refusing to cooperate with federal agents on duty could have serious consequences. It was intimidation language built to make the other person feel that the only reasonable way out was to comply, and it would have worked with most people. Kemba was not most people. 15 years in a metropolitan police force, including 6 years in a violent crimes unit where high-pressure situations were the norm rather than the exception, had given her an ability to keep a clear head in circumstances that would cause most civilians to fall apart. She knew intimidation language because she had herself learned to use it as a professional tool. She knew when an approach had legal foundation and when it was theater. And what Hollis was doing in that moment was theater. She responded with a statement the video captured with complete clarity, and that became, in the weeks that followed, perhaps the most shared sequence of the entire footage. She said she understood what he was trying to do, that she respected his role, but that she was also a law enforcement officer, that she knew her rights, and that he needed probable cause to demand her identification, which he clearly did not have. Hollis's reaction to that response revealed something fundamental about the mindset that had guided the approach from the beginning. He was visibly thrown off, not angry, at least not explicitly, but with that particular expression of someone who has built a mental script for how a situation should unfold and suddenly realizes the other person is not following the script. He had arrived at that gas station with a very specific expectation of how that interaction would work. Someone would be approached, would be intimidated by the presence of 2 armed federal agents in tactical gear, would immediately provide documents, would be checked in the system, and the situation would be resolved in minutes. No part of that script included the possibility that the person being approached would know the law better than he did and have the training to articulate it precisely in the middle of an armed stop. It was at that moment that Pruitt, the agent who had stayed in the background until then, entered the conversation. And the way she entered revealed that there was a real disconnect between the 2 agents about how to proceed. Pruitt did something Hollis had not done. She asked Kemba directly whether she was an American citizen. She did not ask for documents. She did not assert anything. She asked. It was a slightly different approach, and anyone with interrogation experience would recognize that Pruitt was trying to find a way out of the situation Hollis had created without openly admitting the stop had no foundation. Kemba replied that yes, she was an American citizen, born in Atlanta, Georgia, and that she was a lieutenant in the Metropolitan Police. Then, and only then, she slowly reached into her back pocket, removed her wallet, and presented her police identification. The silence that followed lasted perhaps 3 seconds on the video, but those who have watched the footage describe those 3 seconds as the moment you can see, in real time, 2 agents simultaneously processing the weight of what had just happened. Hollis looked at the identification, looked at Kemba, looked at Pruitt, and then looked at the camera on his own chest, as if remembering for the first time since he had stepped out of the vehicle that all of this was being recorded. It was not the discovery of the credentials that was written on his face in that moment. It was the calculation, the instantaneous and involuntary reassessment of everything that had been said and done since he arrived at the station, being reprocessed now through the lens that the person in front of him had legal authority equivalent to his own and the means to use every second of that video against the department. Pruitt was the first to speak after the silence. She began saying there had been a misunderstanding, that they were running an operation in the area, that the suspect profile had generated the approach, that there had been no intention of causing any kind of embarrassment. It was the beginning of an apology constructed with the calculated precision of someone who knows they are on very dangerous ground and is trying to find the right words to minimize the damage before the situation escapes completely from their control. Kemba let Pruitt finish. She did not interrupt. She did not display satisfaction or anger or any emotion that could be used to reframe what was happening. When Pruitt finished speaking, Kemba did something very simple. She asked if she was free to go, and when Hollis said yes, she returned the identification to her wallet, the wallet to her pocket, removed the fuel nozzle from the tank, with the care of someone finishing an interrupted task, got in her car and left the station. Hollis's camera followed the vehicle until it disappeared from view. Kemba Davis drove in silence from the gas station to her home. She canceled her medical appointment. She went inside, sat at the kitchen table, and stayed there for a period of time she later described in interviews as difficult to quantify. Not because she was in emotional collapse, but because she was doing something that 15 years of training had prepared her to do in critical situations. She was organizing, reconstructing the sequence of events in chronological order in her own mind, identifying each relevant moment, assessing what she had and what she would need to transform that experience into something that could not be dismissed as a misunderstanding or an isolated incident without consequences. She knew that what had happened at that gas station had a precise legal name. She knew she had evidence in video format that no defense attorney would likely be able to neutralize. And she knew that the decision she was about to make would determine whether that incident ended. As another episode swallowed in silence or as a lawsuit with real consequences for real people and real institutions, she called the police union that same afternoon, not to seek emotional support or to report the incident informally. She called to speak with the on-call attorney and begin the formal documentation process. She described every detail with the precision of someone giving a deposition: time, location, identification of the agents, exact sequence of events, specific words used, positioning of the agents, status of the weapons. The attorney who took her call interrupted her narrative twice, not to ask questions, but to confirm he had correctly understood what he was hearing. The second time he interrupted, he said something that Kemba later repeated in interviews, as the moment she fully understood the dimensions of what she had. He said that what she was describing, if confirmed by the footage, was one of the clearest cases of racially motivated stops by federal agents he had seen in 23 years of labor and civil rights law. The formal request to preserve the body camera footage from Hollis and Pruitt was filed within 2 hours. Simultaneously, the union notified the Metropolitan Police Department, where Kemba served, about the incident, which triggered a series of institutional procedures that ICE had clearly not anticipated when its 2 agents stopped at that gas station that afternoon. Because Kemba was not merely a citizen with violated constitutional rights, she was an active police officer, which meant the incident crossed jurisdictions, involved interinstitutional relations between different public safety agencies, and had implications that extended well beyond an individual's civil action. The Metropolitan Police Chief was personally notified, and his reaction, according to people who were present at that meeting, was one of an indignation that required no rhetorical construction to be genuine. ICE, upon being formally notified of the complaint, initially responded with the standard protocol of any federal agency facing a misconduct allegation: acknowledgement of receipt, opening of an internal investigation, indeterminate timeline for conclusion, language carefully constructed to neither admit nor deny anything before the facts were internally assessed. It was a response that anyone familiar with how these agencies operate would immediately recognize as a damage containment strategy, not a genuine commitment to transparency or accountability. But there was one element in this specific case that made the standard wait-and-see strategy far more dangerous than usual. The body cam footage was ICE property, but the preservation request had been legally filed before any internal decision about the fate of that material could be made. And Kemba's attorney had made absolutely clear in the notification that any alteration, degradation, or loss of that material would be treated as obstruction and added to the action as an aggravating element. 3 weeks after the incident, the footage was released, not voluntarily by ICE. It was obtained through a formal request under the Freedom of Information Act, and when the video was watched for the first time by Kemba's attorneys in a conference room at an Atlanta law firm, what they found was more than they had expected, not only because the footage confirmed every detail Kemba had reported, but because it showed additional elements she herself had not been able to see at the time. Camera angles revealing the exact positioning of the agents, the posture of the weapons, Hollis's expression in the seconds following the presentation of her credentials. It was material that, in the words of the lead attorney on the case, made the ICE defense not merely difficult, but virtually impossible to construct on any argument other than admitting the stop had been a serious mistake. When the video became public weeks later, The reaction was immediate and of an intensity that IZCE was clearly not equipped to manage. It was not just social media outrage, though there was plenty of that. It was national news coverage framing the case not as an isolated incident, but as evidence of a systematic pattern of racially motivated stops by IACE agents that had been documented across multiple states in previous years. It was members of Congress demanding formal explanations from the agency's director. It was the ACLU issuing a statement citing Kemba's case as an example of a practice requiring urgent congressional investigation. And it was, above all, the image in that video. 2 armed federal agents blocking a black woman at a gas pump with the caption, "All right, let's make this simple," frozen on the screen. That had the kind of visual clarity that requires no additional narration to communicate what was wrong with that scene. The lawsuit was filed in the federal court for the Southern District of Georgia 42 days after the gas station incident. The document was 97 pages long. It was not the kind of petition rushed together by an attorney who had just heard their client's story and was betting on a quick settlement. It was the kind of document that revealed weeks of meticulous work, every allegation anchored in specific jurisprudence, every violation connected to established federal precedents, every element of the video referenced with precise timestamps and corresponding technical analysis. Kemba's attorneys had built a case that operated on multiple layers simultaneously, and each layer was independently devastating for ICE's position. The first layer was the most straightforward, the Fourth Amendment. The stop had occurred without probable cause, without reasonable suspicion based on specific and observable behavior, and without any concrete element connecting Kemba to the suspect. The agents were looking for beyond general physical characteristics shared by an enormous portion of the population. The petition cited Supreme Court precedents that had clearly established that racial profiling alone never constitutes reasonable suspicion, that vague correspondence with a generic description does not justify a detention, and that the use of disproportionate, intimidating force in a baseless approach amplifies the constitutional violation rather than mitigating it. Each of those precedents was applied directly to the facts documented in the video, creating a line of argument that any federal judge with civil rights experience would immediately recognize as solid. The second layer was the Fifth Amendment, protection against compulsory self-incrimination and guarantee of due process. The attorneys argued that the language Hollis used during the stop, specifically the references to the serious consequences of not cooperating with federal agents, constituted coercion, designed to force Kemba to provide information without due process of law. This layer of the argument was more technical, harder to communicate to a lay jury, but was potentially the most costly for ICE in terms of precedent, because if the court accepted that interpretation, it would effectively be saying that the standard language used by ICE agents in field stops constituted unconstitutional coercion in a systematic way, not just in that specific case. The third layer was where the case became truly historic. Kemba's attorneys had done something few firms would have the resources and willingness to do. They hired investigators to research the complaint history against the specific ICE unit to which Hollis and Pruitt belonged. What they found transformed the case from an individual action against 2 agents into a systemic action against an entire unit and against the supervision that had allowed a pattern of racially motivated stops to develop without consequences. There were records of at least 16 formal complaints against agents from the same unit in the previous 3 years, all involving stops of Black or Latino individuals without documented probable cause. Of the 16, 14 had been internally archived with no disciplinary action. 1 had resulted in a verbal warning. 1 had been referred for external investigation and then quietly discontinued. 16 complaints. 0 real consequences. It was the type of pattern that transforms an individual action into institutional liability. And institutional liability carries a financial cost of a completely different order of magnitude. The Department of Homeland Security, under whose supervision ICE operates, was added as a secondary defendant in the action. This was strategically significant for 2 reasons. First, because it expanded the potential financial liability beyond the resources of a single operational agency. Second, and more importantly, because it forced the involvement of a supervisory level that normally remains insulated from the consequences of individual field actions. The federal government defense attorneys assigned to the case made an initial assessment that was described by sources close to the process as concerning for the government. And that is a description government attorneys rarely use about cases they consider manageable. The video was incontestable. The unit's history was documented. Kemba's identity as a police officer with verifiable credentials made any argument that there had been reasonable ambiguity in the situation impossible, and the national coverage of the case had created a level of public visibility that made any attempt at a quiet resolution politically unviable. During the discovery phase, Kemba's attorneys requested documents that the government initially attempted to block under a claim of deliberative process privilege, a legal doctrine that protects internal government agency communications related to the policymaking process. The court partially denied that claim and ordered the disclosure of a series of internal communications exchanged between unit agents, supervisors, and agency attorneys in the weeks following the incident. What those documents revealed was, in the words of the judge overseeing the case at a hearing that became public, sufficiently concerning to warrant an independent investigation beyond the civil action. The communications showed that unit supervisors had been informed about the incident with Kemba the following day, that at least one supervisor had internally described the situation as a misidentification that could be managed, and that there were discussions about how to frame the incident in internal reports in a way that minimized the appearance of misconduct. It was not obstruction in the most technical sense of the term, but it was evidence of an institutional culture that prioritized protecting the agency over holding agents accountable, and that had implications that extended well beyond that specific case. Settlement negotiations began before the case came anywhere close to trial, and the federal government initiated the conversations, not Kemba. That detail matters because it inverts the dynamic that normally characterizes these processes. In cases involving powerful federal agencies on one side and individual citizens on the other, it is almost always the plaintiff who feels the pressure of time, litigation costs, and the emotional exhaustion of a prolonged legal battle, and who eventually accepts a lower value than they deserved, just to bring it to an end. The government counts on that. It builds its strategy around it. It drags the process out, multiplies procedural demands, raises the cost of each stage until the other party simply no longer has the endurance to continue. But Kemba had the police union funding the action, had a law firm that had identified the historic potential of the case and was willing to go all the way, and had a video that became more devastating to the government's position every time it was watched. The government blinked first. The initial proposal the federal attorneys placed on the table was rejected by Kemba's attorneys without prolonged negotiation. It was a number the government's lawyers probably knew would be rejected, the kind of opening offer that functions as a probe, trying to gauge the other party's desperation before revealing how much they are actually willing to pay. The response from Kemba's attorneys was a counter-document that not only rejected the figure, but formally expanded the scope of the non-financial demands in the settlement in a way that made clear the case had never been primarily about money. The demands included the termination of Hollis and Pruitt, the permanent revocation of both agents' federal certifications, the opening of an independent investigation into the 16 previous complaints archived without disciplinary action, the implementation of a revised training program for the entire unit, with annual external auditing, and the creation of an independent oversight mechanism for field stops conducted by ICE tactical units in the southeastern region. The government resisted several of those demands. The termination of both agents was the one that generated the most prolonged negotiation, not because the government believed Hollis and Pruitt were defensible in the face of the evidence, but because conceding on that point opened a precedent that other federal agencies feared. If ICE agents could be terminated as a direct result of a civil action for racial profiling, that created a replicable legal pathway that civil rights attorneys across the country could use in similar cases. It was a precedent the government wanted to avoid at any cost, and Kemba's attorneys knew that and used that knowledge as leverage during negotiations. Every time the government retreated on the termination issue, Kemba's attorneys responded by increasing the financial figure being sought. Of this, and a message was simple: the protection of the precedent you want to maintain has a price, and that price increases with every round of negotiation that does not result in an agreement. The final settlement was signed 11 months after the gas station incident. The full amount was never publicly disclosed, but partial public records and sources close to the process indicated it was substantially above $2 million, with some estimates reaching $4 million when including litigation costs and attorney fees covered by the government. Hollis and Pruitt were terminated. The federal certifications of both were revoked, preventing rehire by any federal security agency. The independent investigation into the 16 prior complaints was opened and resulted, months later, in disciplinary actions against 3 supervisors who had archived complaints without adequate investigation. The revised training program was implemented, and the independent oversight mechanism, though in a more limited form than Kemba had originally requested, was established as a binding part of the settlement. What happened to Kemba afterward followed a path that people who knew her described as completely consistent with who she had always been. She went back to work. She remained a lieutenant. She did not request a transfer, did not seek accelerated promotion using the case's visibility as a stepping stone, did not become a public figure beyond what was necessary to ensure the story was told accurately. She gave selected interviews to outlets that demonstrated a commitment to covering the case in its entirety, and not just its most sensational aspects. And in each of those interviews, she said versions of the same thing that Irvo Otieno had said months earlier, in a different case, in a different state, with superficially distinct but structurally identical circumstances. She said she won not because the system worked for her, but despite the system, that she had resources, training, and specific circumstances that placed her in a position to fight, and that for every person in that position, there were hundreds who did not have those tools and who simply absorbed what had been done to them and moved forward because the alternative seemed impossible. There is a line that connects the case of Kemba Davis to the case of Irvo Otieno and to dozens of other documented cases in recent years where law enforcement officers were racially profiled by their own colleagues within the same system while off duty. That line is not coincidence. It is pattern, and what these cases have in common, beyond the race of the people approached and the absence of any legal justification for the stops, is that all of them only resulted in real consequences because the people involved had the knowledge, the resources, and the determination to transform a humiliating experience into a documented legal action. The system did not correct itself because it recognized it was wrong. The system, it was forced to respond because someone had the power to force it. And that distinction between voluntary correction and compulsory accountability is perhaps the most important thing anyone watching these stories can carry with them when the video ends.